Ladies and gentlemen, good morning. It is my pleasure to open this 12th conference of the European Court of Arbitration. As you see from its name, the Mediterranean Middle East Conference, it stresses the importance of this part of the world.
We would like to welcome you to Cyprus. Also, we would like to thank our President, Mr. Mauro Sammartano, for choosing Cyprus for the 12th meeting of the European Court of Arbitration. We'd also like to thank the UCLan University and Stephanie, Vice President, for giving us this space. We must note that our European Court of Arbitration for Commercial Disputes, the Cyprus Chapter, has its seat in this university, and also it has a courtroom, very nice courtroom, that it can be available for arbitrations. We're hoping to develop this branch so that it can be used not just in Cyprus but also for other neighboring countries.
As you will hear today, the European Court of Arbitration has national chapters located in many countries and the European Mediterranean region. The objectives of such chapters are to promote nationally arbitration and mediation throughout the wider region through education, awareness activities, and conducting proceedings under the rules of the European Court of Arbitration.
Yiannos is appearing on behalf of the respondent, and Dennis is appearing on behalf of the claimant.
Cyprus is totally independent from the other two state powers, and it is also impartial and honest. There has not been a single case of corruption among judges since our independence in 1960. Very few judges were obliged to resign as a result of their performance in recent years, but not for reasons of dishonesty. Despite the above merits of our judicial system, we do suffer from long delays in the administration of justice. Both the Supreme Court and the government of Cyprus are keen to see the expedition of the judicial process. We are now undergoing a major reform in our judicial system in order to solve the aforementioned serious problem. New courts are about to be created. Furthermore, the Supreme Court favors and encourages the alternative methods of resolving disputes, and mainly arbitration. Arbitration is considered as a reliable, fair, relatively cheap and quick method of resolving disputes.
La solution unitaire répond en grande partie aux postulats selon lesquels ce qui est bon pour l'arbitrage international l'est aussi pour l'arbitrage interne.
The due process is one of the two main principles of the international arbitration, the other one being the independence and impartiality of arbitrators. There were opinions which considered also this the second pillar, the independence and impartiality of the arbitrators, actually being included in the concept of due process. This is due to the fact that both these principles are an application of the most general principle and requirement of procedural fairness.
The main points of the decision can be summarized as follows. First, the arbitrator shall be considered as an officer of the court. Second, as such, he has the responsibility to observe the procedural rules applicable to court proceedings. Third, the arbitrator shall have the right to receive oral testimony, but not to use such testimony given before another person, even before the court proceeds. Fourth, such testimony must be taken in the correct procedural manner, that is to say, to receive the testimony of each side in the presence of the other. In this case, the Supreme Court concluded that wrongly received testimony may constitute a defective execution of the arbitrator's duty, which is a reason for setting aside their award.
In France, Racine, Vidal, in Spain, our friend Moreno, they got to the crucial point to choose the seat of arbitration. It's very, very important. Not very easy. The power sometimes is in the close. I can't read. The power is belong sometimes to arbitrators. But the problem, meaning, is obligatory of faculty choice a lawyer like defendant. In Italy, we have a rule. Exactly.
International arbitration is not unusual to have the laws of more than one state apply. The main laws applicable are the law governing to the substantial contract, the applicable law, the law to merits, the law governing the arbitration procedure, the law of the seat, the law governing the arbitration agreement, lex arbitri, and the law of the state where the award will be enforced.
Enforcement of arbitral awards is the time of truth in international commercial arbitration. It is the time when you find out if your investment in time and money that led to the issuance of an arbitral award has been worthwhile. Enforceability of arbitral awards is heavily regulated as it ultimately leads to coercive measures undertaken by a state acting in its capacity as imperium.
In other jurisdictions, the tendency is to review the merits whenever possible, and some Arab countries, not all of them, are in the first row in this. Another problem exists when a state is a party to annulment proceedings, because there is an inevitable risk that the local court be, even if only psychologically, be influenced by the importance of the state.
Since the conduct of arbitrators plays an integral role of public perception of arbitral process, enforceable ethic regulation at international level will increase the public confidence in the arbitral process and its legitimacy.
If that's so, the conclusion is, it was nice to be with you. I hope the discussion was of some interest to you. Thank you for coming. Thank you again to our Deputy Chairperson and her university for hosting us so graciously. Thank you.